It is your lordship. I beg to mention item number 17 of today's daily list, my lord.
Item number?
17, madam.
Yes.
Yes, I got a petitioner and my learned senior is having, he's not well, my lord. So I am praying for an adjournment.
Okay, Mr.
Mr. A.K. Boro, my lord.
Okay. You have informed the other sides.
No, I am from the petitioner's side. I have taken consent from the respondent authorities also.
Mr. A.K. Boro, Learned Counsel for the petition, has submitted that in the case, in this case, he is being led by Mr. S. Mitro,
Yes, Mitra, my lord.
Learned Counsel for the petitioner. Mr. Boro has submitted that Mr. Mitro is indisposed and he has thus prayed for an adjournment of the case. So it is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. As prayed for, release the case after
2 weeks, my lord.
2 weeks on the date to fixed by the office.
May it please, Your Lordship. Lordships, I beg to mention item number 3 of today's list was. In this case, I am led by Senior Counsel Mr. I. Chaudhary. He has some difficulty today, my lords. I seek an adjournment. I have informed the other side. My lord.
For respondent number 9 to 11.
9 and 11.
9 and 11.
9 and 11. Okay, Mr. S. Vishwakarma, the Learned Counsel, has submitted that Mr. Akhtarul and Senior Counsel who is leading him in this case has some personal difficulty today. He has thus sought for adjournment of case for 2 weeks. Mr. A. Aforesaid, Learned Counsel for the respondent number 9 and 11, is present. First of Mr. Vishwakarma has submitted that consent has been taken from the other respondents to make the prayers. Press the praise along. Release the case after 2 weeks on the date to fixed by the office.
There is an interim that may be continued, my lords.
Interim order.
Yes.
The interim order passed earlier shall continue till the next date of listing.
Obliged.
Maybe you should. I am praying for listing this matter on Friday.
What is the admission?
On admission and 2 motion matter, please.
Motion, okay. Admission according to the court master.
Motion.
May I please your lordship?
Motion is okay. Friday.
Right.
May I please your lordship? Lordship, with the consent from other side, I beg to mention item number 10, lordship. Lordship, if lordship peruses order dated 30/3/2026, lordship. Lordship, matter was substantially heard by my Lord Justice Mr. D. Barua, lordship.
Okay, Mr.
U. Ghosh on behalf of DP.
U.
Court.
Ghosh, Land Counsel for the petition has submitted that the matter has been substantially heard by coordinate bench within bracket D. Barua. On 33/2026. Mr. So-and-so has submitted that the matter be listed before the appropriate bench. First of raised to verify the same and thereafter release the case before the appropriate bench.
May I please, Lordship? Lordship, I beg to mention item number 12, Lordship.
12.
12, Lordship, in this case, Lordship, I need to file a Lordship list of land, Lordship, mentioning the land which has not been paid, for which the compensation has not been paid, Lordship. So for this purpose, Lordship, I need some time, Lordship. 2 weeks time, Lordship.
Mr. A.M.S.
A.M.S.
Mazumdar, Counsel for the petition has sought listing of the case after 2 weeks in order to file an additional affidavit.
No, Lordship, just a list with a.
In order to obtain
Prepare a
further
list.
instruction
Yes.
to complete his instructions in a matter. First of
Obliged.
it is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer. As sought for, release the case after 2 weeks on date to be fixed by the office.
May I please the Lordship? Lordship, I beg to mention item number 11.
Yes,
Lordship, matter become infraction.
you are Miss
Ambora.
M. Bora, Learned Counsel,
I can do here.
appearing on behalf of
P. Gauhati.
Mr. P. Gauhati. Learned Counsel for the petitioner has submitted that the subject matter of the writ petition has become infractious. First up, in view of the above submission made by Ms. So-and-so, learned counsel for the petitioner, the petition is dismissed as impractious.
Daily list for admission, items 1 and 2.
Yes, Mr. Upadhyay, some instructions.
Proceed, I could contact my client also when I have prepared my affidavit. During the course of the day, I am filing my additional affidavit lost.
Okay.
So for the
Yes.
contempt is concerned.
Mr. S.K. Goswami, learned counsel for the petitioner, is present. Also, Mr. N. Upadhyay, learned counsel for the respondents, has submitted that an additional affidavit on behalf of the respondents is going to be filed during the course of the day. He has thus sought for an adjournment of listing of the case after
My fiction.
1 week. After 1 week. With the said additional affidavit on record, first of release the case says on. Did you got it?
18th May, 1805.
Not.
Item 4.
May I please, Your Lordship? Lordship, may kindly pass over the matter for the time being, Your Lordship.
Timing. Yes.
Items 5 and 6.
Actually, 5 and 6, we have got the refund. The matter was pending for interest. We have got instructions from the client to withdraw. They are not pressing for the interest.
Okay. 5 and 6 both.
Both, same SSC.
Mr. A. Kanodia, learned counsel for the petitioner, has submitted that he has instruction from the petitioners not to press the writ petitions. First of in view of the above submission made by Mr. Kanodia, learned counsel for the petitioner, both the writ petitions stand dismissed as not pressed.
Great. Lordship, the instruction needs to be handed over.
Oh, you can give it. The document placed by Mr. Kanodi is kept with the case record.
Great.
Here,
For the Customs Department.
okay, Miss
P. Upadhyay, Your Lordship.
P. Upadhyay, learned counsel on behalf of
Mr. S.C. Kayal, Your Lordship. Senior
S.T.
Counsel.
Kayal,
Kayal.
learned senior counsel and standing counsel, customs is in attendance.
Item number 7.
Pertains to freezing of bank account matter. Petitioner matter.
But anybody has appeared?
Yes, madam. They appeared, madam. On the other previous date, they were not present, madam. Also, I don't see. They appeared on 23/2/2026, and they were supposed to file an affidavit, madam. On the next date fixed, madam. On the next date fixed,
Okay.
madam. The council was not present, madam.
Mr. M. Sharma. So it is the respondent or two is the main respondent.
The bank, madam. Now, as the bank account has been freezed, madam,
Hmm,
the operation of the business has been.
yes.
In a similar situation, madam, but in that case, madam, affidavit was filed, but the amount which is involved in the offense manner, that was not ascertained manner. In that case, manner, if I may place the order, manner. In my case also, the amount is not specified. Manner. If matter comes to paragraph 5, manner. Paragraph 5, the case has been referred, manner. The Honorable Madras High Court has observed that under the guise of investigation, order of freezing of entire account without quantifying amount or period cannot be passed, as the same would be in violation of the fundamental rights. Now, paragraph 10. Am I paragraph 10? While the learned counsel for the petitioner may be correct in contending that there cannot be a blanket restriction on the operation of the account and the disputed amount may be kept in lien, this court also finds force in the contention advanced by Sri Nandi learned counsel at this stage. It may be difficult to quantify the amount involved and also the aspect as to whether there is involvement of the petitioner in the crime. Next paragraph, after giving an anxious thought to the rival contentions, this court is of the opinion that the equities would be balanced and interests of justice would be served if a direction is given to allow the petitioner to operate the aforesaid bank account with certain conditions. This court is also of the view that in a given case, a balance is required to be struck between the interest of investigation on the cyber fraud, which is creating a menace in the interest of a bona fide and innocent.
Okay, Mr. Munir, try to contact Mr. Sharma. We'll take up after some time. Right, let us try. If you have contact number of Mr. Sharma, I think it is Minal Sharma.
Yes, so mine.
After some time.
Item number 8.
First, I appear for respondent number
Yes.
1, 2, Lordship.
Have you filed any affidavit?
No, Lordship, we'll be filing it today, Lordship.
Okay.
But give a short date for that.
Yes, Mr. Ali. Let them file.
Freezing of accounts or audit.
Mr. Ali, learned counsel for the application is present. Mr. J. Islam,
Lordship.
learned counsel for the respondent number 1, 2, and 3 has submitted that the counter affidavit on behalf of the said respondents is going to be filed during the course of the day. Full stop. And next Wednesday, did you place the case on next Wednesday, huh?
13.
Or Tuesday?
Tuesday.
With the counter affidavit of the respondents on record.
Obligation.
For orders, item 9. Item number 9.
Yes.
Lordship, here, in last order we have submitted, in last occasion we have submitted, there are some defects, submitting the proposal. And it was directed to submit a proposal in appropriate format in 2026 and 2027. Lordship, may kindly grant us 2 weeks time so that we proceed.
Have you submitted a fresh demand proposal?
Lordship, we are waiting for the update, Lordship.
Mr.
R. Sahana on behalf of DNAT.
R.
R. Sahana on behalf of DNAT.
Sahani.
Lordship.
Sahani.
Lordship.
Sahani.
On behalf of DNAT.
On behalf of Mr. DNAT. Standing Counsel PWD has submitted that he is yet to receive instruction whether a fresh demand proposal for the financial year, yes,
For the petition.
quote, colon, 2026 2027 with the correct format dash Roman 1 capital Agor Silo and format 2 for onward necessary process has been submitted by the concerned executive engineer or not. Yes, submitting so, Mr. Sami has paid for listing of the case after 2 weeks in order to enable him to obtain the said instruction. First of Mr.
A.R. Pal on behalf of
A.R. Pal, learned counsel for the petition is present. List the case again on after 2 weeks.
29th May 2905.
I'll open it.
Oh, timing would have been that is fine. Matter.
Time being matters. Item number 4.
May I start in that case? Mr. Kyal
Lordship,
can.
Mr. Kyal is on legs in port number 1. He'll be coming shortly.
No. The main party would be Kyle. By what time he'll be free?
Lordship, in 10 minutes.
10 minutes.
Mm.
Argi theke.
Item 7 to also.
7 to 2 here no hobo lage. Okay. No matter. After some time.
For hearing.
Oh, Ida.
Mr. Gupta was on Lake Sudan that day,
Oh,
and
you are supposed to address.
I saw him in port number 1 now.
Oh,
Can pass over for the time. One minute.
Item number 15.
It may kindly pass over the matter for timing, Lordship.
Item 16.
there is no representation from any of the parties
16.
today on call. This one. Yes. Again after 2 weeks. On a date to be fixed by the office.
Item number 18.
Lordship, I'm appearing of SK Talula, my lord. He is still on the way, man. He's starting.
Last order so. Reply to. Oregano. Replies. Reply.
Counters are filed
Lordship.
by the Corporation Department.
Corporation Department has not come up.
Huh?
So far as the respondents are concerned, in the interlocutory application they had filed for vacation, they have taken the stand.
Who?
Respondent number 8 has filed in the main writ petition.
Who is Jasmana?
Respondent number 8, my lord, is Fakrul Haq, this
That is a private person.
private person, Abdul.
No, what is the stand of the state?
They have to come, my lord.
Question is whether such kind of irregularities would invalidate the proceeding or not. And state has to make a response.
Lordship.
No affidavit. What is this? And how it can be? What is the submission of the state? That no affidavit is going to be filed or what?
That
Huh?
they are not filing it. As of now, they have not filed it.
Yes, you represent whom? SK
SK Taluga, my lord.
Yes, what is the stand of the state?
My lord,
Or else?
I don't have any brief, my lord,
Huh?
with him, my lord. He will be present in the second half, my lord.
Second half. Then I will not wait for them. Let them file affidavit then.
Lordship.
Heard Mr. S. Boni, Learned Counsel, Senior Counsel for the petitioner, and Mr.
K.A. Sodial on behalf of
K.S.
K.A. Sodial.
A.S.
K.A. K.A. Sodial.
Sodial,
Sodial.
Learned Counsel on behalf of Mr. S.K. Talukar, Learned Standing Counsel, Corporation Department for the state respondents. There is no representation on behalf of the
I guess final to key.
private respondents today on call. Posto. Para. Mr. Sadial has submitted that Ms. Talukar, Standing Counsel Corporation Department, has some personal difficulty to conduct a case today. So the state respondents are expected in a matter or in a litigation involving issues in view of issues involved in this litigation, state respondents are expected to file a counter affidavit, its response. So, no such response, no response has been filed by the state respondents till date. So, let the case be listed after 3 weeks. In the meantime, the state respondents will ensure that its counter affidavit is filed in the repetition. The interim order passed shall continue till the next period.
I think I don't want to. So this is the matter wherein I was a unit claiming exemption under notification 20/2007 for the Northeast refunds. My commercial production lordship started in 2009, and after that I filed my first refund claim. That included excise duty as well as cess and higher education cess. Now, lordship, the department rejected that claim on the ground that I am not an eligible unit as per the definitions contained under the notification. I do not satisfy the, I am an eligible unit, but I have not fulfilled the conditions. That is, I have not utilized my entire SENVET credit. That was one of the conditions. But my eligibility to claim refund was determined to be eligible unit. That particular refund got rejected on that ground that I have not utilized SENVET credit. Therefore, I did not appeal. It was a correct position. Against that order, the department preferred an appeal before the Commissioner Appeals, challenging the determination made by the Assistant Commissioner that I am an eligible unit under the notification 20/2007. Commissioner Appeals dismissed the departmental appeal and held, yes, I am an eligible unit. Against the rejection of Commissioner Appeals order, the department preferred an appeal before the tribunal. The tribunal also rejected the departmental appeal and held the petitioner before your lordships, to be an eligible unit under 20/2007. Against the rejection of the tribunal order, the department preferred an appeal before the division bench of our Honorable High Court. Our Honorable High Court also answered the substantial questions of law frame against the department and in favor of us, and held us to be an eligible industrial unit. Now, after this, for all the periods from 2009, 2010 onwards till 2014, I had already filed my applications for the purpose of claiming the refund, which were not processed by the department on the ground that my eligibility itself is disputed. After the division bench order comes, the commissioner gives us a hearing and says, yes, now the board has accepted this order of the division bench. They are not going to appeal before the Supreme Court. And the commissioner passes an order whereby commissioner determines the special rate. Because in the notification lordship, one was the general rate, and if my value addition is more than the 28% slab, I have to file some certificates, then my special rate is to be determined. The commissioner determined my special rate and accordingly processed my refunds. Now, while processing the refund, commissioner passes two orders. One order regarding what should be the special rate of value addition, that was passed, and subsequent to that, the commissioner passes the order wherein all my pending excise refund claims was processed along with interest. But when it comes to cess, the commissioner in one paragraph writes that this amount will not be disbursed as held by Honorable Supreme Court in Unicorn Industries. My claim, 2009, 2017, the judgment of the Supreme Court in SRD Nutrients came and held cess to be also eligible because if there is no excise duty, if we are paying excise duty, then cess is also a duty on excise.
Let us understand the documents first.
Lordship. Lordship, may kindly take page 44 is the first refund rejection order. Lordship, Lordship, para 4, page 45.
You are a manufacturer of plywood.
Plywood, Lordship.
What is this notification?
Lordship, this notification I have annexed at page 41, Lordships.
What does it say?
It says, Lordships, that any person who has set up a unit in Northeast, subject to conditions therein, if they pay the excise duty, they will get a refund. They can claim the amount of the duty paid through cash ledger, the PLA, will be refunded to them. And then this notification was amended from time to time, Lordships, wherein the concept of value addition was brought in.
Where is that below edition?
Lordship, this is the notification which contains 41, page 41, Lordship.
Which part value addition?
Para number 4.
Para number 4.
Lordship. The manufacturer at his own option may take credit of the amount of duty paid during the month under consideration, other than by way of utilization of Senvet credit under the Senvet credit rules in his account current, maintained in terms of Part 5 of the Excise Manual of Supplementary Instruction issued by the Central Board of Excise and Customs. Such amount credited in the account current may be utilized by the manufacturer for payment of duty in the manner specified in Rule 8 of the Rules 2004 in subsequent months, and such payment would be deemed to be the payment in cash.
What is the special rate? Special rate?
The special rate was brought in after that. That is not a dispute, Your Lordship. That has been decided.
No, I don't know.
Lordship,
I want to understand it.
At that particular, the amending notification I have not attached, Lordships. This is the base notification, which was referred to in the order, Lordship. That is, I'll place, Lordships.
The central size. Oh, no. It's very central access very What is the concept of this Senvet credit?
Senvet credit, Lordship, in excise regime, whatever I have purchased, raw materials and services, wherein excise duty or service tax has been charged by the supplier, that amount is called a Senvet credit for me, which I utilized for payment of my output duty on my manufacture. Like, Lordship, in GST, we have input tax credit, ITC, that is Senvet credit under the erstwhile. Only the name has changed. Lordship, that notification, the special rate notification is discussed in page number 90 of the adjudication order, subsequent order fixing the rate, Lordships. The Lordship says I will place that particular portion.
Okay, now come to page 44.
44 lordships. 44 lordships. I'll place from starting lordships. Page 45, para 4 would state what I had filed during that particular month, lordships. The SSC had filed refund claim of 123,600, including cess and higher cess.
Your special rate is 36%.
Special rate, Lordship, it was fixed by the Commissioner on 21/1/25 at page 86, Lordship.
Huh?
At page 8.
What is the rate?
Lordship, the special rate was fixed for different years. Like for 10-11, it was fixed at 76%. For 11-12, it was fixed at 51%. For 12-13, 47.55%.
Okay.
Lordship. 36%, Lordship, was in the notification. Base rate.
Okay, this order has been passed on 20,
Lordship
page
is
44.
page 44, Lordship, it is 21/4/2010. Lordship will get the date at page 48.
44 itself.
44, Lordships,
21/4/2010.
dated 21/4/10. Yes, Lordship, it is signed at page 48 of the same day.
Then what happened against
Lordship,
this?
This order was carried in appeal by the department. And the appellate authority at page 49 passes the appeal order.
So it is revision.
Lordship, in excise law, it is like both of us can go to appeal.
Huh?
Respondent can go to appeal. So it was also an appeal by the department.
Arising out of appeal by the Assistant Commissioner. So some order in review was there.
Lordships, order in review for an order in original to be appealed by the department, the committee of commissioner has to decide the legality of that order under 35EE. If the order, accordingly, they pass an order in review, by which the commissioner then empowers the assistant commissioner to file the appeal.
Just a minute. So it is, in appeal, it is held that you are a new unit
I am an eligible unit, Lordship. I am a new unit for the purpose of claiming exemption.
for eligibility.
Lordships, only to the extent of eligibility.
But benefit was not granted.
Refund was not granted because the condition of send-back credit I had not fulfilled, Lordships.
Then what happened?
The Lordship Department took this appeal order also before the Honorable Tribunal at page 58. Lordship, the operating part of the order is at page 62. The department appeal was dismissed.
Yes.
Lordship. Now, Lordship, department took this order before our Honorable Division Bench at page 63. And by judgment dated 25/10/24, this was also dismissed. The substantial questions of law was answered against the department. Operate the relevant discussion is at page 69, para 13 on.
So first substantial question of law framed is itself incorrect. Yes, then?
Then, Lordships, because every month I was still filing my refund claims and I was taking the credit on self-assessment basis, not on the special rate because special rate was never determined. So department issued me the self-claim which I had done in my return. Department issued me 23 protective show cause notices because I have claimed on the basis of self-credit, but this is pending adjudication. So 23 show cause notices were issued, which after this order got dropped while in page at page 71, Lordships. While order dated 21/1/25.
Right order dated
29 January 2025, Lordships. Page 71. The commissioner in the table, Lordship, records all the 23 show cause details.
page?
Lordship, page
Yeah.
72 onwards. 72, there is a table.
Yes.
72, 73 table, Lordship, and Lordship may kindly the relevant portion of discussion and finding starts at page 80. Before that, Lordship, it is the same factual things has been repeated. Page 80, Lordship, again, the facts are again narrated. Page 84, para 29 is the recording by the commissioner. Page 84, para 29, Lordships. The department has not filed further appeal in the Honorable Supreme Court against the said order of the Honorable Gauhati High Court and accepted the order dated 25/10/24 by the competent authority as intimated by Superintendent Law Legal Office of the Commissioner CGST Central Excise Dibrugarh by letter dated 22/1/25. And then para 31, Lordships. Accordingly, I find that the protective demands of rupees this, which amount were availed as benefit of exemption as amended, are no longer maintained and liable to be dropped. So this was only on the self credit which I had availed. Those protective show cause notice came to be dropped, Lordships. Lordship, at page 86, the same commissioner determines my special rate as per amended notification 23/2008. Page 86, Lordship, by the order dated 21/1/2025. Annexure 7.
No, that is prior to 21/1 is prior to 29/1.
Lordships, both the things were done simultaneously, Lordship. First, my special rate was determined, and then my protective demands were dropped. Protective demands, Lordship, it is
No,
have
that he has mentioned.
yes in
No, till
29/1 order he has
30,
mentioned
there are
that.
30 he has mentioned.
Lordship, he has mentioned that the competent authority in the meantime has determined the special rate. That order is, Lordship, page 86. Discussion finding starts as, Lordship, page
Just
8.
a minute.
Lordship.
Do you have the notification of 27/3/2008? That's notification number 17.
17 of 2008.
Uh-huh.
Lordship, I have just
For determination of this special rate, there was a separate line of proceeding. Applications were,
yeah.
Applications-
Line of proceeding.
applications were rejected,
Yes.
appeals were filed
Sested
like that. Okay. Just a minute.
Lordship, I have the soft copy.
Just
Email-
send it to the court master.
Lordship.
Okay,
Lordships.
then,
Then Lordships, the Assistant Commissioner at page 95 wide order dated 11th of February 2025 granted me the refund of differential excise duty as per the special rate fixed along with interest, but did not grant me the refund of education cess and higher education cess. Lordship, may take page 95, Lordships. Is the order dated 11th of February 2025. Discussion finding starts at Lordship page 98, para 10 onwards. Page 103, para 23. He determines what for 5 years how much I am differentially eligible.
so 2 crore 45 lakh.
Lordships, he determines at para 23 and he processes the same with interest.
So you received that amount.
I received. Lordship, para 24, Lordship, before Lordship takes
Wait.
para 20. Lordship, there was a communication. Lordship, I will like to hand over this communication. This is the Lordship, may kindly take the third page first. Third page, Lordships, is my letter addressed to the Assistant Commissioner, wherein I had in 2019, 22nd November, received by department on 26th November, had asked them that now SRD Supreme Court has clarified that cess refund is also payable. So I gave them this letter asking for the self-credit of the cess refund also. In 2019.
Item to refund.
And we annex this statement, Lordship, regarding how much cess we have paid through our PLA. That much only, to that extent only I can claim.
Yes.
Lordship, second page, wide communication dated 17/12/2019. The department sends back my claim to me. Lordship, I apologize, it is stapled incorrectly. Lordship, please refer to your application for refund of cess and higher cess as per Honorable Apex Court order dated this. It has been found that your eligibility for benefit of the exemption under 20/2007, which is a prerequisite for availing the benefit, has been challenged by the department before this estate, which your Lordship has seen the department appeal was dismissed. Thus, the case is still pending and registered under Central Excise Appeal number this. Therefore, your claim for refund is hereby returned. Now, Lordships, how can an officer sitting on the, wherein there is on the judgment of the Supreme Court, he sits on this judgment of Supreme Courts, and by this letter, he sent back my refund claim. When there was no dispute regarding my refunds. And suddenly, Lordship, now kindly Lordship takes para 24, what he writes. What different stances now department takes. The SSC has also claimed refund of cess and higher cess, stating that the cess amount is also refundable along with excise duty, whichever applicable. They have submitted a copy of the order dated 10/11/17 issued by the Supreme Court of India, wherein it is declared that cess is to be levied on the aggregate of all excise duties. Therefore, it is clearly referred that when there is no excise duty payable, as it is exempted, there would not be any education cess as well. I have gone through the matter on refund of education cess and higher education cess, and I find SSC has submitted an order dated 10/11/17 issued by the Honorable Supreme Court of India, 2-judge bench in the matter of SRD nutrients, civil appeal number this. In the said order, appeals of the party was allowed and held that the appellants were entitled to refund of cess and higher cess which was paid along with duty, but excise duty itself was exempted from levy. However, I also find that the Honorable Supreme Court of India 3-judge bench has also given a judgment dated 6/12/19. The date is very critical in my case. In the matter of Unicorn Industries, wherein the following decision is made by Apex Court, para 43. Thus, it is clear that before the division bench deciding SRD nutrients and Bajaj Auto Supra, the previous binding decisions of 3-judge bench in Modi Rubber and Lita Textile Private Limited were not placed for consideration. Thus, the decision in SRD nutrients and Bajaj Auto are clearly per inquirium. The decisions in Modi Rubber and Lita Textiles are binding on us, being of coordinate bench, and we respectfully follow them. We did not find any ground to take a different view. Resultantly, we have no hesitation in dismissing the appeals. The judgment and order of High Court are upheld and appeals are dismissed, no costs. While passing the above order, the Apex Court observed the following. Para 40. Notification dated 9/9/2003 issued in the present case makes it clear that exemption was granted under section 5A of the Act of 94.
Yes. Yes.
41 also. Concerning additional duties under the Act of 1957 and additional duty of excise under the Act of 78. It was questioned on the ground that it provided for limited exemption only under the acts referred to therein. There is no reference to the Finance Act 2001 by which NCCD was imposed and Finance Act of 4 and 7.
What is NCCD?
Lordship, National Calamity Duty. Like education cess, similarly other nature of cess which was imposed through Finance Acts. Education cess was also imposed through Finance Acts. The notification was questioned on the ground that it should have included other duties also. The notification could not have contemplated the inclusion of education cess and higher education cess imposed by Finance Acts of 2004 and 7 in the nature of duty of excise. The duty on NCCD cess and higher education cess are in nature of additional excise duty, and it do not mean that the exemption notification dated 9/9/2003 covers them, particularly when there is no reference to the notification issued under Finance Act 2001. So, Lordship, it was decided by the court that if the notification only speaks about excise, it will exempt excise. Incidental excise duties like cess or any other would not be covered under exemption. This was what Unicorn finally decided. Para 28, that is what the learned officer notes. From the above, I find refund of cess and higher cess cannot be made, and accordingly the same is denied and sanctioned in accordance with the above stated judgment of Apex Court.
There was.
Lordship, may I place the other full judgment? This is where, Lordship, subsequent.
This education says and higher education says has been brought in by under what provision?
Lordship, it is brought in by Finance Act. Finance Act governs Chapter 5 governs service tax, Lordships. Under that Chapter 5 of the Finance Act, cess was introduced, which was to be levied as a percentage of duty only. Cess, Lordship, education cess was levied as 1%, 2% of the basic duty, and higher education cess 1% of the basic duty. It was not a.
Yes.
Lordship. So, Lordship, now my submissions, Lordships, are twofold. Unicorn, which the department relies, is much later. Prior to that, only my claim had crystallized. It is not a case of the department that I was not eligible for that amount. My claim for cess and higher cess had crystallized, which is also clarified by their own letter, dated 17/12/2019, wherein they say we will not process your refund because an appeal is pending.
The question at that point of time in those appeals
Was
was with
eligible.
regard to your eligibility to claim exemption under those notifications
Lordships.
on the ground that their contention was you were not a new unit, but an old wine in a new bottle,
Lorships, Lorships. But Lordship,
which was ultimately
decided in my favor.
decided in your favor by the division bench. Thereafter, they stopped pursuing that.
Lorships. So Lordship,
If I have read it correctly.
Lordship, that is what, Lordship, I would have.
Because the very question of eligibility for exemption under the notifications were questioned by them.
I go down to that. Lordship has correctly pointed out, and that is why they then processed my claims.
They said, yes, after that,
There was
they
a full
stopped
stop.
pursuing.
Lordship.
Then they decided, then they granted you the exemption for this excise, so and so,
Lordship,
plus the interest also.
so Lordship, this would mean there was never any dispute with my claims.
The question is here, Mr. Kanodia, question is about the source of power.
Source of power.
Source of power.
Lordship,
And just because it is not that SRD nutrient, I have not read it.
I will play.
I have to read it. I have to read it.
Brought this, I
And,
not placed also.
yes, you have annexed it.
Lord, I will place those. Sir.
No,
They
you have
have
annexed
not-
it, but I would need some time to go
Not-
through it, right?
I am just trying to give an overview.
So SRD nutrient, it appears from the order of that authority,
Lordship,
which is annexed at
Page 96.
page 96, that it stands between two earlier three-bench judge decisions and a subsequent three-judge decision. It stands between.
Between and after that also now Supreme Court has clarified that all those which were done, which were processed, when the claims were vested, as per SRD, those cannot be undone.
Whether your claim is in process or not, that is one
Lordship,
issue.
I will place that. For that, Lordship, I rely on
What
these
is SRD nutrients?
two. Before that, Lordship, I have placed these two circulars for your Lordship.
What more circulars? Or you have not annexed all?
No, Lordship, these are circulars with the nature beneficial circular. Lordship, 17/12/2019, that letter I had placed before your lords, wherein they had stated my claim was returned on the ground that an appeal is pending. Now, Lordship, this situation was dealt with by the board as to what will be the fate of refunds in case of any appeal is pending. As you may kindly take 2003 circular, the single page circular first. It categorically lays down what is to be done in such situations. Subject Central Excise and Customs disposal of refund rebate claims where special leave petition civil application along with stay application is pending at Supreme Court. I am directed to refer to clause 1 and 2 of Board Circular 572 dated 22/2/2001, which inter alia provides that in cases where department has filed SLP civil application along with stay application against the adverse order of High Court CGET, as the case may be, no unilateral action should be taken by commissioners to release goods, order, refund, and decision in such cases where stay order is not forthcoming. Should be taken only in consultation with the board. In this connection, a number of reference from field formation have been received. Board has examined the matter. It is observed that the above guidelines requiring consultation with board in such cases dilute the legal position that the order of the High Court Tribunal should be implemented unless a stay has been obtained from higher judicial forum on implementation of the order. Further consultation with the board in such cases may cause into delay in finalization of the refund claim. Accordingly, the board has decided to permit jurisdictional commissioner to take decision in such cases on merits at their level to grant refund or release goods without seeking permission clearance from board. However, in the matters concerning Supreme Court, the jurisdictional commissioner should continue to pursue with the board for early disposal of stay application. Now, Lordship, in my case, they return my application stating that my appeal is...
Mr. Kanodia, firstly, if I have understood correctly or incorrectly, firstly, you have to satisfy me that in spite of having the eligibility to obtain exemption under Central Excise Act under section what 44 or what, whether you are eligible to seek exemption for education cess and higher education cess. If you cross
First,
that wall, then the question of processing of your application for refund or something would come. First, you satisfy me on the basis of the law of enunciated by the Supreme Court in SRD and all other cases which have been referred to, that whether after a party is eligible for exemption under these notifications, which is relatable to a source of power
under 5A of the sentence.
under section
Of the
5A
sentence.
of the Central Excise Act, is automatically eligible for exemption from higher education cess and education cess, which is relatable to a different source of power.
First,
If I have understood or maybe I may be wrong,
no, Lordship,
right? So you have to first satisfy me, yes, I am eligible, be it a different source of power. These notifications are relatable to specifically 5A
Fine.
of the
Central Excise.
Excise Act.
Right.
And I asked you, you said that the source of power for education cess and higher education cess is,
Finance.
yes, relatable to Finance Act. Now, you have to show me that first, yes, on this count, I am eligible for exemption from education cess and higher education cess. Then the second question would come that whether your application is liable to be processed or not. So this, I may be wrong, but I have to ask this question
With,
for my satisfaction.
with due respect,
That is why I asked, where is that notification imposing education cess?
Lordship, I was on different tangent because that was not disputed by lower officers, but still I will satisfy.
No.
I will satisfy.
Yes, disputed it. You
He's
were wrong. You were wrong. You were wrong.
Lordship,
You were wrong.
Lordship,
On that count, you were wrong.
Lordship.
I have read. I don't read partially.
no,
I have read it. I have found that he has,
page 104, para 24.
yes, 27.
Para 25.
Let us see. Unicorn. I have not read it, but let us see.
Unicorn is at page 123, Lordship.
The
Relevant portion is at para, the quoted portion, Lordships.
whether he has quoted it from SCC or something else, I don't know. No, you have attached, but his paragraph may not tell you with the SCC paragraph because SCC changes the paragraph. Where is that paragraph? Suppose page 104.
Lordship, page 104.
He has quoted paragraph 40 and 41
Lordship.
from this.
Unicorn judgment.
Huh?
I will show your Lordship this particular paragraph in the attached citation.
No, in the citation. Which paragraph?
Lordships.
What is the starting page of this
As
second
what
paragraph?
Unicorn is at page 123.
123.
Three.
Okay. Yeah, fine.
Take the book, please, to the book will come.
Or it starts from which page?
Lordship, it starts at
It's
Page number-
132.
132, Lordships.
Okay.
Lordship, the relevant para I have found, Lordship, it is at page
Notification number
Lordship, para 48.
48.
Yes, Lordship, para 48 and 49.
It was rendered on which date?
Lordship, it was rendered, Lordship,
6/12/2019.
12/2019.
And SRD?
SRD was, Lordship, dated 2017 sometime, Lordship, it is.
It was decided on 10th November 2017. Page 108.
November 2010.
November 10,
Just
2007.
2017.
And my that letter was before the unicorn judge.
No, that is why
That is why,
I have
Lordship.
posed the two questions. First, your eligibility with regard to source of power.
Lordships.
If you crosses,
I
you
will,
cross that hurdle,
I will try to cross.
then the question.
Plus.
Thereafter, it will be a smooth ride for you,
Yes.
Lords, I will.
right?
I will only place SRD in that case, Lordship. SRD covers
No,
my.
SRD, now you see all this, what is how a judgment is to be interpreted. And when it comes into force, how it is to be treated has to be enforced, right? Where it stands in between, I don't know, I have not read paragraph 48 and 49 fully, but it appears it stands in between.
Lordships. That is what I am also trying to satisfy a lot, that it is in between, so I cannot be rendered remediless. I cannot be thrown out like this by this letter dated 2019. It is because
It is on the second issue.
Lordship, first issue.
First issue
Lordship, first,
is, and suppose, and Mr. Kanodi, I have to read it.
Lordship.
You have to give me time.
Lordships,
It is not that I'll suddenly jump into a conclusion.
no, not in at all a hurry, Lordships. Lordships is giving me a patience hearing. That is what, as
No,
an
I'm
officer,
trying to
I-
understand.
we want that, Lordships. Nothing
First,
more.
I'm trying to understand myself. And there's observation in paragraph 50 and 51. I used to forget the name. Unicorn.
Unicorn.
Once it is held par imperium, it has no binding force.
Lordship, now that has subsequently Supreme Court clarifies that in Saraswati Agro. Lordship, that is also attached. Kindly take, Lordship, page 180. A division bench of the Supreme Court has clarified what should, and our court, Lordship, our court has also decided a top camp cement, that also I have attached. That what is the fate? Can department restart a recovery basis the unicorn? Our court in
No,
Lordship.
that is a recovery.
Yes.
Recovery stands on a different footing. Mr. Kanodia, don't try to compare with
Yes, Lord.
Just,
recovery and
Lordship, for per incurium. I'm just trying to show that.
par incurium. We can go to the constitution bench. What is par incurium?
Lordship, that is.
If you want to
No, Lordship.
go to what is the concept
I
of par
don't-
incurium, then we can go to the
No,
constitution bench
what-
judgment.
I did not venture into that territory at all, Lordship. Lordship, Saraswati Agro, may I please?
What is the equivalent citation in SCC? because I can read this small.
Lordship, I will. The civil
Can you
appeal,
cite? Can you cite?
the
I'll
SEC. Just 1 second. I'll just use myself.
A2. Naam to software. Yes, we'll resume after 5 minutes. Go a bit slowly, huh? I mean,
I have given the SEC.
physical discomfort.
Lordship,
Yes. This is okay. That Kamalak Sri Finance.
Saraswati Agro, Lordships.
No, page 183.
Page 183 is Staff Chief Finance. That is on that, Lordship, that is 2019 letter, December 19, which the department returned my letter. That is bad exercise of power on that tangent.
Okay.
But that is secondary, Lordship. First, I have to pass the hurdle which your Lordship has asked me.
That Saraswati.
Saraswati, Lordships. Saraswati Agro, I have handed over that copy, Lordships. Lordship, I am placing, Lordship, we have heard Mr. N. Venkatraman, the learned AG, appearing for the petitioners in extenso.
Yes.
He pointed out that this court, in the case of SRD Nutrients versus CE reported in this, gave a ruling contrary to the judgment previously rendered by 3-judge bench of this court in case of Modi Rubber versus Union of India in this. In a subsequent decision, namely Unicorn Industries reported in this, the judgment passed in SRD Supra was overruled and it was held that the exemption from payment of excise under a notification granted would not exempt the payment of education cess and secondary education cess. It was also observed in the judgment that the judgment passed in SRD was per inquirium. The learned ASG, during the course of his submission, has brought to our attention an order passed on 27 September 2021, referring the very decision passed in SRD Nutrients to a larger bench, having regard to the fact that the state decision was per inquirium in as much as it has not considered the earlier judgment of this court in Modi Rubber. Therefore, he submitted that this matter has to be connected with the said matter and the judgment to be passed in line with Unicorn in SRD Nutrients Limited. When the reference is answered, would follow in this case also. We have given our anxious consideration to the submissions made by the learned ASG in light of what has been stated by the High Court in para 74 of the impugned judgment. In SRD Nutrients, it was held that when payment of excise duty is exempt under a Central Excise Act, then the 1% cess and secondary and higher education cess payable on the aggregate duties of excise will also be exempted. However, later in the case of Commissioner of CGST versus Narmada Industries, later in the case of Unicorn Industries versus Union of India reported in this, the aforesaid judgment in SRD Nutrients was overruled and it was held that although the exemption from payment of excise duty under a notification is granted, there is no exemption from payment of cess. Therefore, the SSE who has paid the excise duty and cess was not entitled to the refund of cess which has been paid. Also, where the refund has been made pursuant to the judgment in SRD was no longer valid. With regard to the reference order made on 27 September 21 on a miscellaneous application filed by the revenue seeking to undo the judgment in SRD Nutrients, which was overruled in the subsequent judgment of this court in Unicorn, the question is whether there was a need at all to refer the matter to a larger bench. This was for 2 reasons. Firstly, such an application could have been filed after,
Could not
have been filed after a review petition in SRD Nutrients has been dismissed by this court. Thus, in substance, by filing the miscellaneous application, the revenue was seeking a second review of the said judgment, which is impermissible in law. Order this rule 9 of CPC. Secondly, by ignoring the explanation to order Rule 1 of CPC and the principle that emerges from the same. What is sought to be contended by the learned age?
It is quite clear.
This is clear.
This is quite clear.
Lordship, Lordship, just 2-3 lines, please.
Because I have extensively dealt with
Lordship.
just recently.
Lordship.
Anyway,
Lordship.
read further.
Lordship, para 9.
No, please read further.
Lordship.
Explanation. Explain to order 47, rule 1. Yes, read.
Rule 1 and the principle that emerges from the same. What is sought to be contended by the learned ASG is that if a judgment is overruled by this court by a subsequent judgment, then the overruled judgment will have to be reopened, and on reopening the said judgment will have to be brought in line with the subsequent judgment which had overruled it. This is not permissible in law for 2 reasons. Firstly, there has to be a finality in litigation, and that is in the interest of the state. Secondly, a person cannot be vexed twice. This is epitomized by the following maxims: nemo debet bis. No man should be vexed twice for the same cause. Interest replicable. I am not reading the Latin words. I am reading the normal. It is in the interest of the state that there should be an end to a litigation. A judicial decision must be accepted as correct. These maxims would indicate that there must be an end to a litigation, otherwise the rights of person would be in endless confusion and fluid, and justice would suffer. That is why the explanation to order 47 rule 1, which is a wholesome provision, has been inserted in the CPC. It states that once there is a subsequent judgment overruling an earlier judgment on a point of law, the earlier judgment cannot be reopened or reviewed on the basis of subsequent judgment. The contention of the revenue is that in view of the subsequent judgment of this court in Unicorn, recoveries could be made from SSC with regard to refund of cess made by the department, or if not paid by the SSCs following the judgment in SRD. In the above circumstance, appeals were filed before High Court by SSCs. In the instance case, the High Court has raised the following substantial questions of law and answered it against the revenue: whether the SSC is liable to return the cess and secondary and higher education cess on the changed view of law as subsequently laid down by the full bench of Supreme Court in Unicorn, overruling SRD, on the basis of which the aforesaid cess was refunded to the SSC. In our view, the High Court has rightly answered the aforesaid question. The High Court, in the impugned order, while considering the judgment passed by the court in SRD as well as Unicorn, has observed in para 74. Applying the aforesaid principle in case at hand, since the SSC has been held entitled to the refund of the cess and higher education cess on the basis of a judgment and order of Supreme Court in SRD, which was in vogue at the relevant time, the appellants are not entitled to make recovery of the said refunded amount on the basis of the subsequent decision of Supreme Court rendered in the case of Unicorn. If such an action is permitted, it will open a Pandora box, and the list between the parties which has attained finality will never come to an end. This would be against the public policy which envisages providing quietus to litigation at some stage. In substance, the High Court has stated that the decision in SRD has attained finality and was binding on the parties. Therefore, the subsequent decision of this court overruling SRD in case of Unicorn cannot have a bearing on past decision which had attained finality, although they had followed SRD Supra, which was subsequently overruled in Unicorn. Otherwise, a Pandora's box would be opened and there would be no end to litigation which is against public policy. That is
right. Absolutely right.
So, Lordship, in my case, just borrowing the reference of this, 2019, when SRD was in place, they accepted my claim. Lordship, kindly sees that later once. What they write. There's no dispute to my claim. Please refer to your application for refund of cess and higher cess.
Firstly, let us go back to 48 and 49 now.
Unicorn.
And have you gone through Kanisk Industries and another one by another bench, and the judgment is authored by Honorable Justice Pardiwala? What is a statutory provision and what is a judgment and what kind of retrospectivity a statutory provision can imply and a judgment
I will not.
implies, right? Now let us again go back to,
Page 1.
I am posing a query, it does not mean that I have from my view,
But-
right? I am trying to understand.
but-
That was a case of refund made to the party on the basis of SRD nutrient. When a review was filed, that was dismissed on the ground or in view of the explanation to Order 1, Order 47, Rule 1, which is regarding review, power of review, read with Section 114 of the CPC, right? So that explanation, because one of the judgment rendered by me in a division bench was just 2 days prior to a judgment of the Honorable Supreme Court, right, which has a contrary view. Then a review was filed, seeking review
Based on the.
of her judgment
I got it.
on the ground Order 47, Rule 1.
That-
But in the review application, they have ignored the explanation to Order 47, Rule 1. So by 2 days before that,
It is.
we have rendered a judgment.
We have-
So we are not in a position to review because of the explanation. That has to be displaced by Honorable Supreme Court of India.
Lots. Appeal license.
Our hands are tied now
Lots. Review
By
has a
law.
very limited.
by law.
By-
So after that, they sought review and that review was dismissed by way of the explanation, meaning thereby their recovery, their intention to recover the amount already granted
Already sanctioned.
was
Closed.
stopped, closed,
Closed. It's a closed.
right?
So my lordship,
That
this
is the
case
case of in the Justice Nagaranda's judgment.
lordship, my case is lordship actually because of the eligibility dispute.
Let us.
This would not have
read
arose.
48,
40. I will please.
158.
Lordship, 158, para 40.
Uh,
The
This
notification,
notification is a different notification,
NCCD it is different.
but the concept. Let us.
The notification dated 9/9/2003 issued in the present case makes it clear that exemption was granted under Section 5A of the 1944 Act concerning additional duties under 1957 Act and additional duties of excise under the 1978 Act. It was questioned on the ground that it provided for limited exemption only under the acts referred to therein. There is no reference to Finance Act 2001 by which NCCD was imposed and Finance Acts of 2004 and 2007 were not in vogue.
So you said by 2001 Finance Act.
In my case, 2004 and 7.
Okay.
Because-
Education says.
By 2004, Finance Act 2004
Ah.
and 2007, secondary and higher secondary education.
Can you supply the relevant portion?
Lordship, Finance Act relevant copy I will provide. I have.
Or Mr.
Finance
Kyle,
Act
you have.
I have
Anyway.
not- I have.
Let us proceed.
The notification was questioned on the ground that it should have included other duties also. The notification could not have contemplated the inclusion of education cess and higher education cess imposed by Finance Act 2004 and 7 in the nature of excise duty. The duty on NCCD cess and secondary and higher education cess are in nature of additional excise duty, and it would not mean the exemption issued dated 9/9/2003 covers them, particularly when there is no reference to a notification issued under the Finance Act. not in vogue at the relevant time, imposed later on by section 91 of the Act of 4 and 126 of Act of 7. Worship, this case, my case is that it was in vogue because my case is of 2009-10 onwards. So it is not, and like NCCD was in vogue.
The concept is to,
Concept.
I said,
Yes.
the concept is to be
That is why I'm
looked into.
NCCD like NCCD.
Facts may be different.
NCCD like in this case it was in vogue. In my case, this was. That is what I. The provision of 1944 Act and the rules made thereunder shall be applicable to refund, and the exemption is only a reference to the source of power to exempt the NCCD education sets, secondary and higher education sets. A notification has to be issued.
This part, yes.
Lordships.
Please read slowly.
A notification has to be issued for providing exemption under the said source of power. In the absence of a notification containing an exemption to such additional duties in the nature of education cess and secondary and higher education cess, they cannot be said to have been exempted. The High Court was right in relying upon the decision of the 3 judges bench of this court in Modi Rubber, which has been followed by another 3 judges bench in Rita Textiles.
Basically, this part.
Source of power.
A notification has to be issued for providing exemption under the said source of power.
Yes.
In the absence of a notification containing an exemption to such additional duties in the nature of education cess and secondary and higher education cess, they cannot be said to have been exempted. Now come back to 44. Page 44. Page 40, page 41.
Page 14, a relevant
First
notification.
line.
Notification, also it is 5A. I will place.
5A.
5A of Central Excise Act, only duty is used.
Yes.
It is not in dispute. I am not disputing that.
Now let us go to 49.
Para 49 of Unicorn.
Hmm.
The circular, may I place?
Yes.
The circular of 2004 issued based on the interpretation of provisions made by one of the customs officer is of no avail, as such circular has no force of law and cannot be said to be binding on the court. Similarly, the circular issued by CBIC in 2011 is of no avail as it relates to service tax and has no force of law and cannot be said to be binding concerning the interpretation of the provisions by the court.
This part, next part. Yes.
The reasons employed in SRD nutrients that there was nil excise duty as such, additional duty cannot be charged, is equally unacceptable, as additional duty can always be determined and merely exemption granted in respect of a particular excise duty cannot come in the way of determination of yet another duty based thereupon. The proposition urged that simply because one kind of duty is exempted, other kinds of duties automatically fall cannot be accepted, as there is no difficulty in making the computation of additional duties which are payable under NCCD cess, higher education cess. Moreover, statutory notification must cover specifically the duty exempted. When a particular kind of duty is exempted, other types of duty or cess imposed by different legislation for a different purpose cannot be said to be exempt. I stop it. I want to address your Lordships. Lordships, there is a concept of duty and there is a concept of cess. Both. Sometimes a duty is generally charged on a taxable value. Say I am importing goods, I am paying custom duty, BCCD, basic custom duty on that value. Then there is a social welfare charge, which is also payable either on that custom duty or on the value, like additional duty of excise. But prior to GST regime, there was something called a CVD, countervailing duty. When I was importing some goods, I had to pay basic custom duty and also CVD, because if that goods had been manufactured in India, government would earn excise duty. So that CVD was put in not on basic custom duty as a value of that due tax, and the taxable value. So if the import value was say 1 lakh, say custom duty 10%, 10,000 rupees. CVD 12%, 12,000 rupees.
Let us understand this concept. I am trying to understand this concept. Excisable goods, plywood, let us. Then, please tell me whether I am right or wrong. Say, you have produced excisable goods, manufactured excisable goods to the worth of X. Now, excise duty payable is say 100. And which can be, firstly, that amount can be, whether concept is right or not. Part of that you can discharge by way of Senvet credit.
Full,
Right?
I can, if I have that
The
balance.
full is okay. Full is okay. Say 50.
50.
Senvet credit at the end of the month was 50.
50.
So by that is to be adjusted.
Adjust.
If I have understood
Lots.
I have not gone through Senvet rules.
Plus
Remains 50.
50.
And because of this exemption notification, you are exempted, say, from paying the balance 50 also. But otherwise, total was 100.
100.
Right? Now, what is the rate of education cess?
Rate of education sets is 2% of excise duty.
So that cess is imposed on rupees 100.
Rupees 100.
Right?
No.
So 2.2 rupee 50 paisa. If it is the entire amount is 100.
If excise duty
Excise duty payable is 100.
then 2% of excise duty will be
2 rupees. And what is higher education cess?
1% of excise duty.
1%. So 2 plus 1.
3 rupees.
3 rupees. So paragraph 49 says even all these are exempted.
If only duty is exempted,
But
then cess is payable.
3 rupees can be determined.
It cannot be Lordships. Why I say so, 2% of nil. If duty is exempt.
That is the law. That
No,
is what,
Lordship,
again, let us read again.
no, that has been clarified by board. 2022.
The board will not.
Lordship,
Board, Mr. Kanodia,
Lordship, just
when
read.
a judgment is there,
I-
right from
2019 December.
no, not because it has clarified the position which was
Modi
existing. Moti
1983.
Rabar. And Moti Rabar is holding the field since when?
1983.
1983. Right. A clarification, a judgment cannot be clarified by any notification.
Lordship, it cannot.
I don't think so.
It cannot.
Right. Para 49 says, the region employed in SRD nutrient that there was nil excise duty. As such, additional duty cannot be charged. This additional duty means education cess, higher education cess. Is also equally unacceptable as additional duty can always be determined. Like I have determined, 3 rupees
If there is,
on 100 rupees.
if there is a value to determine.
Let us.
Yes.
And merely exemption granted in respect of a particular excise duty cannot come in the way of determination of yet another duty based thereupon.
Right.
The proposition asks that simply because one kind of duty is exempted, other kinds of duties automatically fall, cannot be accepted, as there is no difficulty in making the computation of additional duties which are payable under NCCD, education cess, secondary and higher education cess. Moreover, statutory notification must cover specifically the duty exempted, which is page 40.
This is page 1.
When a particular kind of duty is exempted, other types of duty or cess imposed by different legislation, that is Finance Act,
As
different legislation
Finance.
for a different purpose cannot be said to have been exempted. This is the understanding. Now
let
you
it-
clarify. Now you clarify.
No, Lordships, I will agree to this point, the jurisprudence determined by the Supreme Court, wherein there was a case of CVD, customs duty and cess. When I am importing a goods, Lordships, say my custom duty is exempted. I don't pay custom duty determined as nil. But CBD is payable because the notification does not exempt CBD, countervailing duty.
No, here we are only concerned with excise duty
Excise duty.
and additional.
I'm trying to just give an example, Lordships, that when it is in the nature of duty which is calculated on the value itself, like excise duty calculated on a value, cess is calculated on excise duty. And after this judgment, they introduced a new cess called as social welfare charge, surcharge. And Lordship kindly takes this circular once. They clarified the position of the law again in 22.
Who has clarified?
Board, CBIC.
Boy, I'm not.
Lordship, just once. Lordship, just,
No. I'll not look into it.
Lordship, just once for my satisfaction.
Right, since Motirabar,
Lordship, it is considered this, Lordship, just once for my.
who can consider?
Lordship, what is the intent? Why this was given and what?
No, how can a judgment be explained?
No,
When the judgment is clear.
it has not been explained, it has not been referred. But what I tend to explain, Lordship, it is written here. Kindly takes once a look, Lordship. Lordship may not rely upon
These are unnecessary.
Lordship, just for myself. Verification regarding applicability of social welfare surcharge on goods exempted from basic and other custom duty cess. Reference has been received seeking clarification on the issue of applicability of HWS on goods that are exempted from basic duty of basic custom duty or tax or cess, which are levied as a duty of custom. In absence of any specific exemption on HWS, certain field formations have taken a view that HWS shall be payable on notional custom duty as determined on tariff rate. The matter has been examined. HWS is levied and collected as a duty of customs, vide section 1110 of Finance Act 2018, and is calculated at the rate of 10% of the aggregate of duty, taxes and cess, which are levied and collected by central government as a duty of customs on goods imported into India. In this regard, it may be noted that at present, HWS applies at the rate of 10% of aggregate of customs duties payable on import of goods and not on the value of imported goods. If aggregate custom duty payable is 0 on account of an exemption, HWS shall be computed as 10% value equal to nil, as aggregate amount of custom duty payable is 0. Law does not require computation of HWS on a notional custom duty calculated at tariff rate where applicable aggregate of duties of custom is 0. Thus, it is clarified that the amount of HWS payable would be nil in cases where aggregate of customs duty, which form the base of computation of HWS, is 0, even though HWS has not been exempted. Exactly what I was trying, they have placed in words. I was not able to.
So your submission is this has clarified all these judgments.
I'm not trying to say that. I'm trying to say this is an authority of.
What is your submission on it?
I
I'll record.
I am not verifying this judgment, but what is the position in the present case? How the field formation work? Practically, how it is being implemented.
Field formation, how they work is not the issue here.
Implementation of the.
What is your submission in based on this?
My submission.
What is your submission? Kuwa the principle laid down in Modi Rubber followed subsequently in this unicorn and in between SRD nutrients.
My submission, I will place SRD for my submission, Lordship.
It would go by SRD, but SRD falls in between Modi Rubber and unicorn.
And I fall in that period.
Then how it is applicable? This is consistent with SRD.
This,
Maybe.
Post 20, this is 22, Lordship. Kindly see. This 22. The board customs, Central Board of Indirect Taxes and Customs is governing the law in the country, Lordship. It is run by the Union of India.
Then this is.
It is Union of India, Lordship, which is governing and bringing this.
So what is your submission on it?
My submission.
By referring to that.
My submission in that.
In the face of these judgments, 3 judgments, right from Modi Rubber to unicorn and SRD in between. Now, what is your submission by referring to this?
I
For
submitted-
that, I have to record. I'll record it.
No, Lordship, I
No,
am
no,
trying-
no, I'll record it so that I can deal with it.
Lordship, I am just trying to put
That was
in
good.
a place that departments, what instructions, department circulars are being issued in, for the purpose of
Whether,
calculation.
whether,
Calculation, how it is to be Lordship, for example,
this is a clarification to a circular.
no, it is a circular, Lordships.
Circular
This is a
and
circular.
clarification to a circular.
Yes, Lord. It was regarding Lordship. References have been seen. References were given
By field formation.
by field.
So what is your submission?
My submission, Lordship, in the present facts of the case, excise duty, the cess is payable on excise duty. The calculation of cess was done as a percentage on the excise
How
duty.
it goes with the judgments? How it goes along with the judgment?
It does not go, it does not goes with any judgment, Lordship. I am just placing this as an additional point. I am not trying to say, Lordship, that it has clarified any judgment. I apologize, Lordship, if this has fallen from me, but I am trying to rely on this for the purpose of what the field formations board is instructing and clarifying regarding the nature of calculations of cess in case of exempted, in case the basic is exempt. That to that extent only I am relying.
When the High Court judgment, division bench judgment was rendered?
Lordship, in which case? Due to my,
In your case?
in my case, Lordship, division bench 25th of October 2024. Page 63.
And Sestat?
Sested Lordship, 15th of June 2023 at page 58.
So if your application is processed in your favor, then you will be eligible to get refund.
Lordship, I will be eligible to get it.
Refund for the amount
42 lakhs.
charged towards education cess and higher education.
That was determined as 42 lakhs on the basis of notional value and then the basis of special rate also.
We'll hear for some time, Mr. Cal, then
Lord.
I'll revert back to you. But you have to give me some time
Lordship,
for going through the judgment.
Lordship,
Then I may have some more queries.
Lordship.
Yes, Mr. Kyle.
Lordship, here in my submission, Lordship, point for determination because Lordship, whether the petitioner is entitled to refund of education cess after unicorn judgment is passed. Here, Lordship, the claim of the petitioner assessed with respect to excise duty only. Lordship may please to come to page 96. Paragraph, page 103, paragraph 23.
Hmm. Yes.
Paragraph 23, married law.
Paragraph 20.
23. Page 103.
Yes.
The order dated Lordship 25 at 11/2/2025. From the above, the table it is found that the SEC is eligible for refund of rupees 2 crore 45 lakhs so and so for the financial year 2009-10 to 2014-15 in accordance with the special rate fixed order dated so and so by the Commissioner Dibrugarh so and so. Then next page, Lordship, paragraph 24. Already it has been placed before your Lordship. The ICC has also claimed refund of education cess and secondary and higher secondary cess, stating that the cess amount is also refundable along with the education excise duty amount, whichever is applicable. They have submitted a copy of order dated 10/11/2017 issued by the Honorable Supreme Court of India, wherein it is declared that the cess is to be taken is levied on calculate on the aggregate of the all the excise duties. Therefore, it is clearly referred that even there is no excise duty payable as is exempted, there would be not any education cess as well. Then paragraph 25. I have gone through the matter referred matter of refund of education cess and higher education cess, and I find that the SEC has submitted an order dated 10/11/2017 issued by the Honorable Supreme Court of India, 2 judges bench, in matter of SRD nutrients versus so and so. In the appeal number so and so, in the said order, appeal of the parties was allowed by the and held that the applicant were entitled to refund of the education cess and higher education cess, which is payable along with the excise duty once the excise duty itself was exempted from itself. Then paragraph 26. However, I find that the Honorable Supreme Court, in case of one of India in 3 judges bench, has also given a judgment on 6/12/2019 in the matter of Unicorn Industries versus Union of India, arising out of SLP number so and so, which the following decision is made by the apex court. Paragraph 23. Thus, it is clear that before the division bench decided the SRD Nutrients Private Limited and Bajaj Auto Limited Supra, the previous binding decision of 3 judges bench in Modi Rubber and Rita Textile Private Limited Supra were not placed on consideration. Thus, the decision of the SRD Nutrients Private Limited and Bajaj Auto Limited are also clearly per inquiry. The decision of Modi Rubber and Rita Trading Private Limited are binding on the on us, being the coordinate bench, and we respectfully follow them. We do not find any ground to take different view. Lordship, now Lordship see whether their claim was processed and any amount was sanctioned to them. It was absolutely incorrect that any amount was sanctioned to them with respect to education cess. So nothing was returned to them, Lordship, refund to them. And as my learned friend has relied on the judgment of Saraswati Agro, but see the facts of our High Court, and our High Court was decided on Lordship. In that case, what happened? After SRD Unicorn judgment was passed, the department issue notice to the different SSC demanding the issue. Then the SSC approached this Honorable Court. This Honorable Court held that once it has been decided and the amount is refunded, the department has no authority to refund. Yes,
cannot be reopened.
Yes, Lordship.
For recovery.
We accepted, and we also filed a writ appeal that was also dismissed. Thereafter, on basis of Saraswati, Lordship, we didn't proceed further, Lordship. So the present case and the case of in Saraswati Nutrients is quite different, Lordship. Quite different, Lordship. Here, nothing was, Lordship has seen. The amount was determined on 11/2/2025, and the department has considered every aspect of the matter. Let's say now, as on date, let's see whether we can refund the amount on the basis of unicorn. My learned friend submitted that the amount was sanctioned, let's see where it is sanctioned, let's see. Nothing was accepted by the department. Yes, it was at that relevant time, the appeal was pending. So department has returned the entire amount to them, their Lordship, return the application, Lord. When my learned client has submitted letter dated 17/12/2019, it is clearly stated that since the appeal is pending, Lordship, nothing was decided by the department before unicorn was passed. And after an unicorn is passed, Lordship, whether we are entitled to refund any amount to them with respect to irrigation cess. Again, Lordship, if we pass any order that is flouting the Supreme Court's order, and by placing the circular, Lordship, my learned friend, with respect, Lordship, he want to clarify the judgment and negated the judgment of the Supreme Court passed by unicorn, Lordship. So in present fact, Lordship, on the basis of unicorn judgment, they are not entitled to any refund of irrigation cess. Yes, they are entitled to excise duty that was refunded to them along with the interest.
Or which interest?
Yes, Lordship, it was refunded to them. Lordship, in affidavit also we have in paragraph.
Or let us see your affidavit.
Lordship. It was filed on 5th of June 2025, Lordship. Page क्या है?
180.
Lordship, paragraph 10, page 189, running page.
I just read Modi Rubber, just have a glimpse. Law is settled as far back as in 1986.
83.
It was holding the field just because it has been sought to be unsettled by SRD nutrient. Law does not change. It has been only clarified by the clear is that same central excise.
Yes, Lord.
And it did not cover special duty of excise levied under various finance bills and acts. Additional duty of excise levied under the additional duty of excise or any other kind of duty of excise levied under a central act. That being so, law is settled.
So I am placed at such a position today
Modi Rubber
because
is
of 15 years of delay by the department. My refund claim has been rejected. The whole attribution of delay 15 years is to the department.
When did you file your application for refund for
2019, after SRD.
after, sir?
After SRD. Lordship,
Page 106.
When?
Page 106, paragraph
I
33.
had filed my letter on 22nd November 2019, received on 26th November 2019.
Where is that paragraph statement?
Lordship, I have given in separate sheet today, handed over.
Which paragraph, Mr.
Paragraph 33, Lord.
33?
Page 106. Let's say for delay, interest was also paid to them.
33. Application.
For fixation of special rate.
This is for fixation of special rate. This is different.
No, your application for refund of.
Lordship, my first application was filed. Lordship, may take page 44
Application for refund.
for first application.
Test and.
Was filed
Yes,
on 29/12/2009.
29/12.
2009.
Okay. Paragraph page, you want to say?
Page 54, para 1.
Page 44, para 1.
Date is given. So if my learned friend finishes, then I will submit to one seat.
Apart from this, all the judgments, any other judgment? No.
Judgment, Lordships, I have placed this, Lordships.
You have placed all this,
This,
Saraswati.
Saraswati, those are part of record, Lordship. Apart from
Saraswati, then this.
Lordship,
other-
Kamlakshmi Finance, I will place.
Ah.
That is on,
Kamlakshmi.
yes, that is on the ground, Lordships. This per se, this handing over of the letter by the department.
Yes, Mr. Kanodia, when you are coming back?
Whenever, Lordships, please.
No, please
No,
tell me.
Lordship, any day subject to your Lordship's
No.
convenience, I will be there. I'll come.
This month only?
Any day, Lordship, subject to your Lordship's, just give me your Lordship, any preference. I am only not available, Lordship, from 22nd to 28th. Any day before that would, or subsequent. Our Calcutta High Court closes on 22nd.
22nd.
22nd is the last working day and reopens on 8th of June. 2 weeks only. Prior to 22nd, any date, Lordship. Subject.
19th of May? Hearing date?
Not 19th of May. 13th.
Yes, convenient?
Lordship, 13th or 19th, what your Lordship?
1/9.
1/9.
I will, Lordship.
Keep it as perfect.
Lots.
But A. Kanodia, learned counsel for the petitioner, and Mr. S. C. Kyle, learned senior counsel and standing counsel for the respondent. Standing counsel, CDS.
Lordship, in place of standing counsel, I am a special counsel for the department.
That is
A special counsel for the department.
special counsel. Listed by Mr.
K. Jain, Lordship.
CGST, listed by Mr. K. Jain for the respond number 2 and 3.
Lordship.
Anyway, CGST, okay. As the hearing has remained inconclusive, is the case again on 19th. 5/2026 as a part heard.
Lots. Much.
Always a pleasure to address the Lordships.
Yes, Mr. Dekar, you are in a hurry.
We missed out in item number 16, for the respondent. It was reached before we.
16.
Yes, Lordship.
Order has been passed, I think.
Yes, it is fixed after 2 weeks. I just wanted to apologize for Lordship because it went
Order
too early.
16 or 16.
16, Lordship.
When is the order passed?
After 2 weeks.
Yes.
I just wanted to apologize for that.
Okay. You want to record your name?
Yes, Lordship, that will
Actually
be.
sign one hai, Mr. D.
Dekar.
Dekar, Learned Standing Counsel, AIDC. Party
Lordship.
no one was present.
Yes, Lordship. Because
Otherwise, all those cases where one party is present, I have kept it. Okay.
highly obliged.
There is no representation for a petitioner to be on call for issue.
With respect to item number 15, I am preparing for the respondents. What's it the issue in this case, whether duty can be imposed on T? If the Bombay High Court decided the issue against that, Lordship, department has approached Supreme Court. That is still pending, Lordship. Although my land friend is not there.
Today we have adjourned the matter no? or
They-
we kept it.
Timing,
Who is put a petitioner?
Mr. Haveli.
Somebody saw time,
Junior was there.
timing.
We are seeing other court.
The issue is before Supreme Court.
Yes, Lordship.
Okay. Then, Mr.
If this- I guess Bombay High Court is decided the same issue against the department. Against that, Lordship, department file SLP. That is still pending.
Bombay High Court is there.
Yes, sir.
Whether it was heard by another bench?
Yes, sir.
Huh? For further consideration, it is there.
Lordship, it is there.
It is
But-
to be
but-
listed before that bench.
That maybe not.
Kindly taken up at two, Lordship. Very sorry. To raise on like.
If it is to be listed before that bench, then we can.
Lordship at two, Lordship.
Okay, two.
Obligation.
Yes, Mr. Goswami. Mr. Dasgupta is free now. He'll be free.
Yes.
Okay. And Mr. Munir, Mr. Sharma is.
Lordship,
This instruction was placed earlier, but the amount is not specified.
we got one mail, Lordship, to freeze the account from investigating officer.
NDPS case.
Yes, Lordship.
We are not
These are
aware,
the
only now.
investigation.
Update.
And the investigating officer is not a party, Lordship, in this writ petition.
And we are not informed about the, but you kindly see their reply. Page 29 of my read petition.
Investigating officer, Saitual Police Station, Saitual District, Mizoram.
Mizoram.
And Saitual Police Station case number 100/2025, dated 9/2/2025, under section 21C 25 NDPS Act, commercial quantity.
The petitioner is dealing with say, used car business, my lord. Used car business,
Used car means?
second-hand car. Second-hand car, they have a showroom, my lord. They sell used cars, my lord. And we made a representation before the bank, and bank replied, my lord, at page 29. We were not informed about the,
This is, this communication is on which date? 17/12.
December 2025.
Now we have, whether we have additional Advocate General Mizoram station here? Who is the additional? So we can make him party. We can make the inspector the party who can be represented through the additional Advocate General Mizoram. Otherwise, notice and all, it will be very difficult.
Yes.
Right? Item to Duke. Because we don't know what is NDPS case. It was registered on 9/12 and the instruction has been placed on 17 December for freezing the account.
Yes.
when we asked my lord why our account has been freezed, they replied, my lord, at page 29 maybe.
We
can-
passed the order on the basis of instruction placed by, right? Panchali Bhattacharya, okay. We passed the order on the basis of the oral submission made, so that you need not have to file any interlocutory application,
Grateful.
but you have to file a amended cost title. We put it on a date. On that date, before that, you serve a copy. I'll heard Mr. P. Munir, P.K. Munir,
Well.
Learned Counsel for the petitioner, and Miss
S. Yasmin on behalf of M. Sharma.
Mr. N. Das, Learned Junior Government Advocate for the respondent number 1, and Miss S. Yasmin, Learned Counsel on behalf of Mr. M. Sharma, Learned Standing Counsel.
Yes, Lord.
ICICI Bank for the respondent number 2, full stop. Ms. Yasmin has submitted that instruction has been received in the form of an email on 17/12/2025 from the investigating officer of Sidewell Police Station, SAITUAL, Sidewell Police Station, District Sidewell, Mizoram, for the transaction details of bank account number 41360 500 583 000 583 and for freezing of the said bank account. Full stop. It has been informed that the bank account number so and so is under investigation by the investigating officer in connection with Sidewell Police Station case number 100/2025 registered for the offenses under section 21 within bracket small c and section 25 of the Narcotic Drugs and Psychotropic Substances Act 1985 on 9/12/2025. First, instruction instruction has been placed to freeze the bank account with immediate effect to prevent any further debit or withdrawal transaction until further communication from the office of the IO of Sidewell Police Station, case number so and so. Post up. Para, in view of the above information placed by Miss so and so Yasmin, it appears necessary to implement the officer in charge Sidewell Police Station, District Sidewell, Mizoram, as party respondent number 3 in the instant writ petition. First of, it is accordingly ordered. First of, the learned counsel for the petitioner shall file an amended cause title to that effect before the registry. And on submission of the amended cause title within a period of 3 days. On submission of the amended cause title, the registry shall do the necessary correction in the cause title, the records, as well as in the CIS. Full stop. Para, the learned counsel for the petitioner shall serve a copy of the petition, with the amended cause title to the learned Additional Advocate General, Mizoram. Thereafter, list the case on next Tuesday. Wednesday.
13/05.
Serve a copy
I'll do.
after amended cause title so that it can be expedited.
Deeply obviously.
Much obliged, Lordship. Sorry, Lordship, I was not there when the matter was called.
Lordship, in fact, this matter, Lordship, the judgment has already been pronounced by the Bombay High Court in favor of the petitioner on the same issue. And Lordship, for which the respondent also agrees. Nutan warehousing, Lordship, the Bombay High Court judgment is there. Lordship, if I'll take your Lordship to paragraph 29 of the said judgment.
Admission is made
Hmm.
by Mr. Kayal that an appeal has been preferred against the said judge.
Yes, your Lordship. I will, Lordship, pass on the appeal memo, the entire, what are the orders which has been passed in that appeal? Lordship, it has been pending for the last 3 years. No stay has been granted, Lordship. The matter is pending, Lordship. In fact, Lordship, when the no stay has been granted, this is the law of land as on today. Why will I be deprived, Lordship? Only because the matter is pending. It might keep pending for several years. There's no stay. These are all the orders, Lordship. May kindly see the first page where it is indicated what are the orders passed.
Proceed on another date then,
Lordship, for disclosure.
because I am in the midst of a part.
Yes.
We'll examine.
Yes, your Lordship. Lordship, this Nutan warehousing, Lordship, I'll just for the reference purpose, I'm relying on paragraph 19 to 23, 26, 27, and 29. Next date, Lordship, I will paste the.
Okay, and how will you put a petition? Land council put a petition, and Mr. S.C. Kyle. Oh, but whether this is heard substantially by another man?
No, Lordship. It was not heard.
In order it is reflected, but Lordship, Justice Sanjay Mehdi, it was placed before him. But Lordship, no hearing was,
No,
I was not.
the last order is that list the matter again on so and so for further consideration.
But Lordship, nobody appeared on that day.
Huh?
I also know, I was not there on that day.
Okay, okay.
Yes, your Lordship.
That is the only query. Okay, and Mr. S.C. Kyle, United Senior Counsel for the respondents are present. First of as short plan agreed to by the United Counsel for the parties, list the case on DD work, later DD work, hearing later DD work.
Lordship.
Lordship,
If you
Lordship, if my Lordship contention may be recorded is covered and they have said that it's.
how will you hear you?
Yes, Lordship.
I request today I may not prolong the hearing. I am in some physical discomfort. We'll prolong up to 3 because sitting long hours. would be very
Your Lordship
difficult
can
for-
go.
No, it's okay. I can sit up to 3 o'clock or 3:30.
No, it is better to take rest. He goes, sir. It's better to take.
Because I am with
No, better to take rest. Better to
belt.
take rest. No, better to take.
if I recover Thursday,
Better to take rest.
because I am
for
with
good-
belt and all.
All.
I've changed myself to wooden chair.
That's better to take rest.
No, if your lordship is in trouble, because I have a problem.
I have also some problem.
It has recurred.
Yes, and only thing is you have to take rest.
Rest.
Nothing else.
Right now.
So take a rest, if necessary, we not.
Don't think for us.
We can have it on next Tuesday also.
We can have it next Tuesday.
that
Let
will
me
be better.
Take rest.
try to recover.
Take rest just now.
Mr. P.K. Goswami and Senior Counsel, listed by Mr. K. Kolita. Land Counsel for the petitioner. Mr. A. Dasgupta, and Senior Counsel. Listed by Mr. D. Chutia. Land Counsel for the respondent number 3 in WPC number 8150/2017. Are present. Let the case be listed again on next Tuesday for further consideration.
12.
12 নয় 13 বা 14 বা তার আগে
14 then, 14 Thursday.
For
Thursday?
14.
12
For
by
further consideration, the interim order passed earlier shall continue till the next date of listing. So I am sorry.
No problem. You